Okay, welcome everyone. On behalf of ACR-Chicago, we're happy that you're joining us today for the program discussion of the book Noise, A Flaw in Human Judgment by Daniel Kahneman, Olivier Sibony, and Cass Sunstein, facilitated by Rob Olian. Before we start, we'd like to let you know about some upcoming programs that we have. On March 17th at noon, we are doing Mediating Polarized Topics with Felicia Staub. On April 11th at noon, we are doing Tips on Reducing Conflict in Co-Parenting Situations with highlights on how COVID-19 has impacted this. And then on June 13th at noon, we have a program, Keeping Your Head in Mediation with Jeff Truman. All of these programs are listed on the ACR-Chicago website, and registration is open for those programs. If you have any suggestions for programs you'd be interested in, or maybe even like to present yourself or with the group you're associated with, please feel free to contact us via the website. Also, if you'd like to become involved in what ACR-Chicago is doing, either in programming or our other work, we welcome your involvement and participation. Again, you can contact us through the website. Now we'll have today's program with Rob Olian. Just ask everybody, if you're not speaking, if you could please mute yourself to cut back on some of the background noise. Thank you very much. Rob, it's all yours.
Okay, thanks, Mark. And thanks everybody for joining and for taking the time, I hope, to read at least parts of the book. I'm going to just give you a very brief background of where I'm coming from, not because it's of any particular interest to you, but because it will give you a sense of the lens at which I looked at the book, and understanding that many of you who have a different sort of background will have a very different lens for taking material out of the book, and that's hopefully what will be the basis for discussion today. I spent 40 years at Sidley as an environmental litigator. I headed the environmental practice there for the last 20 years or so, until I retired in 2016. And I spent the last 5 years mediating on a very part-time basis environmental litigation matters. It's a very kind of niche mediation practice. I don't try to do general commercial mediation or any of the other kinds of ADR that I know many of you do. Most importantly, for our purposes today, I have 0 minutes of experience leading a book discussion. So bear with me. Don't think you can take advantage of me. I do know that this is a discussion. It's not a college seminar where I'm talking. And so not only am I hoping you'll chime in, you'll need to chime in, or else we're going to be done at about 12:20. Now that you know a little bit of my background, some of you I can see pictures of, others I can see names, a few of you I can actually see. As you say something, maybe just take 10 or 20 seconds yourself the first time you speak, and tell us what your background is, just so we have a sense of how you might be kind of coming at this book, and how it's relevant to your ADR practice. The book identified and noted as it went several areas where that are relevant to ADR, everything from child custody, asylum cases, claims evaluation, litigation analysis, and so on. For me, I took the book seemed relevant to me in at least 2 ways. One is, what do I tell the parties for whom I'm doing a mediation? What do I need to tell them about noise, and to help them reach an agreement? And I'll just, give you one example. First of all, let me just say, for those who didn't kind of pick it out of the book, noise in the book is defined as the variability in judgments that should be identical. And I got a lesson in this very early in my career. I had just made partner. I was doing my first jury trial that I was first chairing. It was a big case for a very large company, and they decided that it was worth doing a mock jury just to kind of sort of test out some of our themes and so on. And so we met in Des Moines, Iowa, which was supposed to be representative of Madison, Wisconsin, which is where the trial was actually going to be. We had 48 people sit in a room and listen to about a 3-hour mock trial that we put on. And then they were split up into 4 groups of 12. And if you've ever done one of these mock jury things that way, basically what happens is if you think of a graph that's divided by an X and a Y axis, each of the 4 areas has a jury sitting in it, and the lawyers sort of stand in the middle behind one-way glass, and you can watch all of the juries deliberate. There was a variance of 20-to-1 in the way these juries kind of came out in terms of their verdict. They'd all heard exactly the same thing, seen exactly the same thing, and yet a very wide range of mock verdicts, if you will. But even more significantly was what they focused on. Somebody's not on mute and you're kind of bleeding through. I'm not sure who it is. And so that was my first lesson in noise, although I didn't really know it was called noise at the time. But I have used that as a mediator ever since. Whenever I get a lawyer telling me, we've got a slam dunk on this issue or a slam dunk on that issue, there are no slam dunks. Even where you have a jury of 12, where in theory you're sort of maybe averaging out, a spectrum of views, you get the wide range that I saw in that initial mock jury that I did, and see the same thing in subsequent ones. And then, think about what happens if you're down to a 1-person judge. And as the book points out, it's kind of scary that your ruling from a judge may depend on whether the Bears won the game on Sunday or not. And somebody, whether he's hungry or not, or she's hungry. Those were some of the things the book, studied and found make a difference in judge decisions. So whenever parties tell me in the process of mediation, we're sure about this, or we assign this a 95% probability, I try to get them to understand that they really need to take account of noise, as we're now calling it. The second way in which I thought the book was very relevant is, as the neutral yourself, you need to be cognizant about how noise might be shaping the mediation process. What is your mood as you're doing the mediation? Are you going to see groupthink when you're doing the mediation? I have seen that. I've done mediations where one party is actually perhaps 6 or 7 insurance adjusters who all have different parts of the claim. And every time I've done this with insurance adjusters, it always defaults to whoever is kind of being the toughest person in the group. Everybody gravitates toward that end. They don't ever meet in the middle themselves. Whoever is the tough person, that's where everybody else goes. You see anchoring in a mediation, and you have to make sure that you, as the mediator or the neutral, you aren't being, you're not subjecting yourself to anchoring effects. And then your own judgment. You are subject to all the frailties and issues that the book notes about judges, who are actually wearing the black robes. And so I think it's important that we all kind of check ourselves as we are conducting or facilitating a mediation or other ADR process to see what noise we might be introducing or not preventing as part of the process itself. So as I read the book, and those 2 main themes jumped out at me. What do you tell the parties they ought to take into account in terms of noise? And how do you shape the process yourself to minimize the effect of noise? It struck me that it might be a fruitful book for discussion by a group. And when we were deciding what to do for this, I said, well, here's a book I read. Maybe it'd be interesting to talk about. So I hope you all found it equally interesting. And now I think we can turn to sort of what struck you about the book,
Excuse me, Paul, could you mute yourself, please?
Sorry. Yeah. Paul Lurie? Paul Lurie,
I
can you
private
mute?
messaged him as well, but it didn't work. So
Okay, thank you, Tom. So with that, I'm going to just throw it open for discussion. You know, any thoughts you have on either of the kind of two themes I identified, but hopefully more, what else did you pick out that relates to your particular ADR practice? You can either, well, since most people aren't on video, waving your hands isn't going to do any good. If you haven't done this before, there's, at least on my screen down at the bottom, there's a participants tab. And if you, I'm sorry, there's a, where do you want? We want the, not the chat. I thought it was on participants. Oh, reactions.
reactions. Yeah.
It's on reaction.
Excuse me, Paul, can you mute yourself, please?
I vote for the host to remove
I
him.
wonder, Christina, if you just here, I just muted him. There we go. Yeah, so if you go down, at least on my screen, I'm on a Mac, at the bottom in the Zoom app, there's a reactions button. And if you click on that, there's another thing you can check to raise your hand. And so if somebody else is talking and you want to raise your hand via the app, go ahead. But otherwise, we can sort of try to see how this goes with people just unmuting themselves when they want to talk. And if I need to play traffic cop, I will. So with that, I'd like to throw it open to whoever wants to chime in. We got to get to at least 12:20 here, folks.
I don't mind chiming in while the other people are thinking. I'll confess, I've only gotten about halfway through the book, and not because I don't want to finish it. It's just this was my goal was to finish it by today, but I didn't make it. So I enjoyed the book, and I think, Rob, what you're talking about, you know, in mediations, do we ask, is a new reality check is, how did you reach your decision? You talked about multiple claims adjusters, and that we know from the book, you know, how biased or how noisy those answers can be. Is, do we ask, what was your evaluation process? You know, how did you come to the decision that this is your value? And we know it's the loudest adjuster or the most vocal one who often gets the final say. But I wonder whether anybody thinks that there's other kinds of questions that we might learn to ask by reading the book. Question, not an answer, right?
Sure.
Yeah.
Anyone?
Yeah, you know, what struck me with both what Rob and Tom have said, you know, is to ask, you know, the participants, like Tom said, how did you reach your decision? And then start asking them more questions and maybe trying to isolate that a little bit to see where they're going with it. And also to get them to think of other things. There was one section where they talked about where, you know, you make a decision and then you step back and you kind of reevaluate how you made that decision and see if there's another decision or choice or another point of view that you've reached, and then put that out there and talk about that. I think that's something that could be done with the participants also. I found a section towards the end of the book that's called the Mediating Assessments Protocol. I guess not to be really confused with mediation, but how that was set up as far as how decision-making was handled, I found to be very interesting. first of all, it's towards the end of that section, but how the process may be the key to making what I'll just call appropriate decisions. And that's something that a mediator can obviously control. In fact, that's probably the only thing that we really do control in a mediation is the process. And by doing that and setting certain things up, if we would get people to reach what I will call better decisions. And in that section on the mediating assessment protocols, they set out a whole thing on how to approach problems or decisions and to break it down. Now, I understand in a lot of mediations that may not be completely appropriate, but I think on some scale, that is something that we can do.
Thanks, Mark. Anybody else? I'll say a lot of the mediations I do now are enforcement cases brought by the government, and they tend to be very large, tens of millions of dollars in dispute over civil penalties and injunctive relief that the government is seeking from a company. And again, I understand that this is going to be very different than the situation where you're mediating a case in circuit court, where you're sitting there and the judge sends two people out of the courtroom. You see them for the first time and have an hour with them. I mean, the work I do will have spent months with me going through documents and reading position statements and briefs and everything. But the parties often prepare a litigation risk analysis, a very lengthy decision tree. We're going to file for summary, if we don't settle today, we're going to file for summary judgment on this issue, and we think we have a 70% chance of winning. And if we lose that, then we're going to assert this defense, and we think we have an X% chance of winning. You build out these very elaborate decision trees. And I always ask parties if I can see their decision trees, and usually they will share them with me. And it's useful for me in a couple of senses. One, I get a sense for where the parties see the case as being wildly different. But often I'll see a party, assign a 90% probability to a chance of success on some issue. And again, my work is perhaps a little different than some. I'm often brought in to at least be partially evaluative as a mediator, not purely facilitative. And I will tell people, I will say, there is virtually nothing I would ever put on a decision tree that I would give myself a 90% chance of being sure about. And I'll give them my little war story about mock juries and whatever. And if you start getting people to say, well, yeah, okay, maybe that should be 75% instead of 90, and you start making those kind of changes throughout an entire decision tree, then all of a sudden you get a wildly different expected value, and your BATNA is a little different, and all of a sudden mediation and settling becomes a much better idea. And so, really what that is then, when you're trying to tell somebody you should not be using 90% or 95%, but you should be using 75% or 70%, that's telling them that there's noise. And you have to account for noise in the system. It may be that if you got the 100 greatest Supreme Court judges together and took a majority vote, you'd win 90% of the time, but you're not going to have that. You've got perhaps a single federal judge who's overwhelmed with a criminal docket, and who's going to look at your brief, and he may just decide, let it go to trial, or I'll wait till these guys are literally on the steps of trial before I send them out to the magistrate and make them settle. And so getting parties to account for noise, even very seasoned litigators who know it exists, is a big part of what I do. And I find that is often what really ends up getting the case to settle is, do you really want to go back, to the company? Do you really want to go back to your board of directors? And now that you've fiddled with your tree a little bit, when you run the simulations, you'll see your outcome. You might get off for $1 million, but it also could be $105 million if things go against you the wrong way. And are you prepared to go back and tell your board of directors you didn't settle for $5 million, knowing that there was a possible $100 million bad outcome there? And that's what I find kind of really gets things moving, is when I can make people really take proper account of the noise that is in the judicial system.
When you talk to people about that, Rob, do you describe it as noise and define noise, or do you use a different approach?
I have always called it variability in the past. I will now, the last couple I've done, the last one I did in person, I actually brought the book with me. And I said, if you guys want to kind of page through this while you're sitting in your breakout room and I'm in talking with the other guys, take a look at pages, whatever it is, 38 and 39 or something, and see if that gets you to change your mind a little bit. And I'm half facetious when I say this, but not entirely. And, but I do say now, I'll pull out the book and I'll say, here's literature if you don't believe me, in my experience. As I said, people hire me because they know I've been doing this for 40 years. And now it's kind of nice to have stumbled across what I consider sort of quasi-academic literature to kind of back up what had been intuitive for me. And as I said, I suspect it's intuitive for a lot of seasoned litigators, but now to be able to really hang a framework on it, I think is very useful.
Yeah, and what I found very persuasive, and I had been familiar with it before, was that study done on judges and sentencing in criminal matters. That's been out there for a while. I don't think it's really been undermined. And even if a lot of us are doing primarily civil type of cases, I think just a brief discussion of that study may make people, think a little bit more about what I will call their supposed certainty of their positions, or how strong their positions are and everything else, and to maybe back off slightly, and that they might be better off considering alternatives or taking a little different way at looking at things, and see what else may be coloring their decision, which arguably, again, even goes to needs and interests for that matter.
Yeah. Does anybody on the call either do criminal work when they're not doing ADR, or even as part of their ADR practice? Guess not. Okay.
I think, Mark, what the data is so impressive, right? And startling when you first look at some of the studies that were done. And so the science behind this theory, it was just shocking to me, is how authentic noise is. But Mark and Rob, or anybody else on the call, do you think in the chair of the neutral now, you're going to be the noise auditor? I know they introduced this concept in some settings, is that we should be auditing for noise. Is that somehow it filters through? Rob, I think what you just discussed is that you're not calling it an audit, but you're really doing the job of the noise audit.
Yeah,
I don't mean to put you on the spot, but if you don't mind, yeah.
As I said, I know a lot of people who in mediation, have it drilled into their head in whatever mediator school they went to, that mediators are to be facilitative and not evaluative. And I consider myself fortunate, but maybe others would view it differently, that a lot of the work I do is not that. I am called on to be evaluative, which is good, because I have a hard time biting my tongue when I am trying to be purely facilitative. I keep wanting to sort of shake somebody and say, wait a minute, you gotta. So yes, I think noise audit is, again, it's a term I wouldn't have used before I read the book, but it's a big part of what I do, what I'm doing now.
And I would add to, to that, not only being a noise auditor, but as I mentioned earlier, this mediating assessments protocol and how we can control the process or set forth a process for decision-making and everything. It implicitly controls noise, but it also sends a structure that maybe we can reduce the noise.
Yeah. Paul, I see your hand is up.
Yes, most of you know that I've been involved for more than 10 years in a guided mediation process. And the most important thing we do, and this is commercial, is in pre-mediation. The most important role of the mediator is to talk confidentially with each one of the parties to diagnose the causes of impasse. And, they range from, monetary to legal to personalities to the kind of things that you guys call noise. I think that one of the things that we look for is how decisions were made. And I work in the construction industry, and oftentimes it's disagreements among experts over, over causation, or disagreements among lawyers, that they have gone through all sorts of analysis, they've used decision trees and all that things, and they told the client, that you're right and the other side is wrong. So we use what's called noise. We don't call it noise. We call it a diagnosis. The mediator has to be involved in diagnosis before we start any settlement negotiation.
Good, thank you. I mean, yes, again, it's one of the luxuries of my practice that I have the time and the parties have the resources. I have never done a mediation where I haven't spent at least a couple of hours on the phone with each of the parties separately before the actual mediation session. And it would just, I can't imagine just sort of going into a session cold. Again, understanding that many people, the kind of ADR they do, that's the only kind of way they go into something is cold. And I'd be interested to hear, from anybody who has has done that kind of work, what your take on some of these things is. Here's where you kind of go in and perhaps your mood that day, your judgment, are you, if you're working in landlord-tenant court, have you just seen so much many bad acts on behalf of landlords that you start out sort of anchored to a tenant point of view? I really am. I think we'd all benefit if somebody with some experience like that would speak up. Make sure I'm seeing everybody here.
I mean, I've been doing some of that landlord tenant, and with these court cases, unlike you, Rob, we don't really get any information ahead of time about the case, the parties, or anything like that. What I kind of do in effect is just kind of take a deep breath, try to clear my mind, and then just by telling myself I'm supposed to be the neutral, which is the same thing that I'm telling the parties, I'm telling myself to just be careful as far as weighting, WEIGHT one side or the other as I'm listening to them. And then just to be balanced in the approach, if you ask one side, how confident are you that you will be successful if the case goes to trial, that you have to do that to the other side. Ask them why they feel confident, what supports their position on that. Have they been in that position before? What has happened? Have they been in that position where they've been disappointed in the outcome? And would it be good for them to perhaps consider alternatives, some type of compromise in the circumstances? But it's something that you have to just be looking at yourself in the mirror and make sure that you're not favoring one side or another. And it can be hard when you're hearing the same thing from one side or the other over and over again.
Yes, and is it, I started out reading the book thinking, how am I going to use this to, get parties to better make their own evaluations? And then as I either proceeded through the book or thought about it more, or some combination of two, came back to this second theme of, boy, there's a lot in here for the way I do the mediation that I need to take into account myself. I asked people to read chapter 11, or at least part of it, on objective ignorance, which the book identified as, it said overconfidence is one of the, more documented cognitive biases. People underestimate their objective ignorance. In other words, and this is really, there's, I think the technical term for this is Dunning-Kruger effect or something, but it's sort of, a little bit of knowledge is a dangerous thing. People think they understand something, they know how to play chess, so they think they can play chess and do well against people who are a lot better than they are. And as mediators, we have to be careful, that we're not, because we know a little bit about something, we're not projecting too much knowledge on, about what we know onto the parties. Michael Nathanson, I see you have a hand up. But you may be on mute, or I don't know. We're not hearing you.
So I haven't read the book, so it may be that what I'm about to say is already in the book. But part of what you're talking about variance in decision making. And so part of that variance is one of the things you've described, which is a judge gets up on one side of the bed versus the other one comes to a different decision. But the other is related to a Nobel Prize that was given out in 1978 by Herbert Simon, who showed that decision-making by people is such that they can't actually be rational about what they're talking about. It's back to this issue of you're saying people are ignorant about something. So basically, the idea is that computers can remember a lot. People can't. And consequently, in decision-making, unless you're connected in some way to somebody who's very good at databases, it's very hard to make a good decision. What he calls is it's satisfying. He says people don't actually make rational decisions. They satisfy things. Satisfies is the word that he uses that got him the Nobel Prize. And so there's that kind of a problem that's ingrained in this. Part of the variance is this business about not knowing the data, which you just raised, and part of it is which side of the bed you get on. The other issue is that it's very difficult in the law to do experiments. So lawyers are very resistant to doing experiments. So as we come up with prescriptions for how to handle something, the question is, how do you know that works? And so we can all have various ideas about how to do it, how to do any of this, but how do you actually show that any of that actually works in the particular circumstance to get the outcome that you're interested in? And for that, you need an experiment. So that's an additional problem.
Yeah, well, you for not having read the book, you touched on three points that I had actually thought important enough to make notes on for myself. Starting working the way backwards, a lot of what we do as lawyers or ADR neutrals is singular. It's you can't, as you said, Michael, you can't run an experiment the way they did with the insurance adjusters in the book, for example, and you know, give 100 people the same information and see how they would come out. That's just not what we can do. But the book warns that you should not take the fact that your decision is singular rather than one you're going to make a lot of times to seduce yourself into thinking there's not noise in that decision. It's there. It's just, there's not going to be any way ever to measure it because that decision is never going to get made again or experimented with again. But you have to, you know, you have to know yourself that that singular decision is every bit as noisy as the decisions of a judge who makes 100 sentencing decisions in nearly identical criminal cases over time. So that was one point. The second point that I think I heard you make was, and here, this was in chapter 6, which a part that I did suggest that people read if they had time. They talk about two kinds of noise in this chapter. One was called level noise, and that's, as the book put it, basically the difference between a bleeding heart judge and a hanging judge. You know, if you litigate in any judicial system for any length of time, you get to know that some judges are very tough on criminal sentencing, or maybe go easy on corporate defendants or whatever it might be. You know, they just have a reputation that in you know, they're either a bleeding heart judge or a hanging judge. Let's leave it at that. And then there's the other thing the book identified that goes along with level noise is pattern noise, and that's the difference in a judge's approach across particular cases, and that gets into you know, might a judge, you know, how is he feeling one day versus the next day? So even though he is thought to go easy on criminal defendants, to take one example, you know, as the book says, if the Bears happen to lose on Sunday, or the judge double bogeyed the 18th hole when she walked off the course on Sunday, Monday may not be the day you want to be getting sentenced by that judge. So two kinds of noise there. And so these are very, you know, a singular, as the book said, a singular decision is a recurrent decision that only happens once. And so while it's not subject to being studied the way the book was able to take on recurring judgments and decisions, the issue of noise is still there.
And Michael, to go on with what you were saying about, you know, someone makes a decision that isn't rational. If you look at it, the book talks about that, and that there is a certain emotional reward when you reach a decision, even if that decision may not be appropriate for whatever reason, but just that emotional reward that you've reached a decision is enough to make you think that it is an appropriate decision, and that when you're making decisions that you should look at things a little deeper to just see that you're not just reaching it just because you're tired of it, or you've gotten to the point where you don't want to deal with it anymore, and that gives you a certain reward, which reinforces what you believe is the appropriateness of the decision.
Mark, if I could just say, and so I think what Herbert Simon was saying was, well, what I'm saying about this is you can parse this variance into two parts. One is the kind of thing you're talking about. Somebody's tired, that kind of thing. That's one aspect of it. But the other aspect of it, which Herbert Simon was talking about and got the Nobel Prize for, was showing that you cannot keep in mind a sufficient number of facts like a computer can to make a rational decision, which is why he says what we do is we collapse a lot of those things that should be looked at and brought into the decision-making process. And consequently, you end up with his view, which is that word he uses, which is satisficing, but not being rational.
Yes.
And that,
Rationality is one section of it. The emotional part is the second section of it.
and there's in chapter 9 of the book, there was, I just plucked this quote out. I'm not actually, I haven't gone back to look at the book since you raised this, Michael, but there was one sentence. It says, there is so much noise in judgment that a noise-free model achieves more accurate predictions than the judge. And what this was talking about was, if you took a judge and tried to model their decision-making by doing, basically regression analyses over a series of decisions that they make, your model of what the judge is going to do is going to be a better predictor going forward than the judge herself or himself would be, for precisely the reasons you identified. The data, the computer, the model can hold more information than a human individual, even if what the computer is doing is really trying to just replicate that human individual. And so with enough data, the computer does a better job of replicating the individual than the individual, him or herself, would do, which was kind of an interesting take.
Sure.
I'm actually looking at this now. I was asked to write a chapter in a book that LexisNexis is publishing, and my chapter is on the application of artificial intelligence to decision making, which is really what Rob just said. Is you can teach the computer all of the decisions that Rob has made in his life, if they're published decisions, and then learn how those decisions are made and maybe take out all the noise. But those decisions were made with noise. The decisions that Rob made are already with noise. And so I'm struggling with how to approach the topic, but it's a very interesting, in light of this book, it's made me think about the issue a bit differently.
And again, in one of the chapters early in the book, in chapter 2, they make the point, although they don't get into it very deeply, they say errors due to unwanted variability don't average out, they add up. And that's pretty scary when you think about it. So
Yeah, can I say something?
sure.
Yeah, this is Paul Lurie. Again, I work, primarily in the construction industry as a mediator, and expert opinions based on computer analysis is very common. And for every party to the case, there's some expert who has this great computer program, that comes up with a totally different, answer to the other ones. So my prediction in the guided mediation field is actually injecting computer analysis is going to increase the amount of disagreement among the parties rather than resolve disagreement.
Okay. And then to the subject of what we as a mediator need to, or neutral need to be doing to reduce our own noise. Another thing from the book I thought was pretty telling or informative was it said most of us most of the time live with the unquestioned belief that the world looks as it does because that's the way it is. And as the book put it, in other words, other people view the world the way I do. And I think, of all the biases that we probably all bring to our work as a neutral, that's maybe one that you have to work the hardest to sort of wipe from your slate as you go in to be a neutral. Everybody doesn't view the way the world you do. We as as professionals, may certainly have a different view of the world than a tenant who is being evicted, or a parent involved in a child custody case, or a parent trying to appeal their child's IEP with their school district. People who think the system is stacked against them, people who think they ought to win because the system was designed to let them win, however they're coming at it. As a neutral, we really have to, at least I find, I always have to remind myself that, my view of the world is not necessarily this, is certainly not what everybody else's is. And I can't superimpose that part of where I'm coming from on anybody else, and should not. So that was, again, another part of their discussion about what makes a noisy system. And when I saw that, it just sort of made me stop and think, all right, what's the lesson? What's the takeaway for that for somebody who is practicing as an ADR neutral?
And just on, oh, go ahead, Laura.
No, I was just.
No, Laura has her hand up.
Oh, I'm sorry. Go
Okay,
ahead.
thank you so much for this discussion, and Rob for outlining this and bringing this to the forefront of how this impacts us as neutrals, because we think just the definition of a neutral is we're objective, but based on this book and all the implicit bias is also that we're really not objective, so it's really difficult to hold ourselves out this way based on just the way our minds work. I have been looking in the book, one of the appendixes, there's a bias observation checklist. It's near the end, it's Appendix B. And I think that is very useful just to see where our own biases are. So even if we're doing we have the luxury of doing pre-mediations in certain cases where we're diagnosing the causes of impasse or the problem, we're diagnosing that based on our own biases, but we are not taking that into account because we think we're experts, right? So I think along the way, even when we're facilitating, who are we reality testing more stringently? Who are we connecting with more? All those things are based on, I think, our variability in judgments. And if I would mediate the same case as you, Rob, we might have very different results, right?
Sure.
And we would mediate it very differently. So I think the more we can objectify what we do, the better. But I think our field is not there yet. So thank you.
Yeah, no, and again, one of the chapters that got a little more mathy, I think, and so I didn't ask people to read it. There was a lot of Pythagorean theorem and mean squares analysis in the book that I largely didn't identify for people to necessarily read. But chapter 7, the discussion of occasion noise, first of all, says occasion noise it's not the largest source of system noise, but it's major. And this was the occasion noise is sort of the kind of lottery affected by the weather, the timing, the mood. Is this the 5th case of the day that the judge is going to hear? I mean, this was all studied in the context of judges. But it went on to say, to kind of eliminate the bias and the noise that you were just talking about, get a second opinion. And if you can't get a second opinion, get a second opinion from yourself. In other words, step back, go out of the room for 5 minutes, tell the parties everybody's on break, send them out of the room for 5 minutes, and ask yourself again after 5 minutes, now how do I think about this? And sort of give yourself your own second opinion. And at least the book, claims that that'll often kind of, bring you back from an extreme and give you a little different perspective just to get your own self-second opinion and then kind of get back into the mix of things. So, even if you don't have the benefit of getting an opinion or talking things over with somebody else who will, bring a different lens and bias to the thing, just talking again to yourself can be very valuable.
Yeah, I agree. Thank you.
And it also, as I was reading this, where they talked about where several people may make a better decision than a single person with arbitration. Are you better off arbitrating a case in front of a single arbitrator if you're a party? Or are you better off arbitrating a case in front of a tri-panel with like 3 people on it, making a decision? Though obviously that brings other issues into play also. But I found that kind of interesting, like with arbitration, whether to consider having more than one party or more than one arbitrator. And it even brings up on cases where both judges involved.
Well, it's interesting you say that. I just concluded on what had been an 8-day arbitration where we had a panel of 3, each party under the contract that they were arbitrating, each party identified an arbitrator, and then those 2 jointly selected a third, and I ended up being the third. And I asked one of the lawyers, I said, because I'd never arbitrated before, I said, why 3? It was very expensive. I mean, the 3 of us, this thing went on for a long time, in part because of COVID. There was a lot of pre-arbitration rulings we had to make. And then, as I said, 8 days, and it took us a couple months to write a 150-page decision. I said, it'd be a lot cheaper if you're only paying. They said, yeah, but with one, you never know if you're just going to get somebody who kind of really goes off the reservation, and everybody, feels safer, even knowing that the party appointees are going to vote for the parties that appointed them. And it comes down to the third person at the end of the day anyway. At least we kind of feel there are some boundaries that get set. I said, all right, well, it makes sense. If you're willing to spend the money to get that assurance, they do it. And, I think most contracts that I've seen provide for sort of that procedure. So but that's the first time I heard somebody articulate why they do it that way. Anybody else?
Okay, can I say something?
Sure.
You should be aware that coming out of the Global Pound Conference, that covered, meetings in 41 cities and sponsored by the International Mediation Institute, that what clients want are mixed mode procedures. And we are, through the IMI, we are establishing mixed procedures where the case actually has a mediator and arbitrators working not together, independently. The mediators are process facilitators. They're the ones that are helping to help design the arbitration so it's most efficient and really deals with the real issues. But the mediators can't talk to the arbitrators. But you ought to go online. The word mixed mode, there's a lot of articles. As a matter of fact, I'm also active in the College of Commercial Arbitrators, where we have a lot of people, also mediators. And CCA is actually implementing and setting up procedures for this combination of mediation and arbitration. And as many of you know, the American Arbitration Association rules, commercial rules and construction rules anticipate that you can have a mediation working at the same time as an arbitration, even though the mediators are not talking to the arbitrators. So pay attention to this word mixed mode. You're going to see more activity. Big companies, often don't like arbitration. They like mixed mode a lot, though.
Well, that's interesting. Our case, my arbitration could have benefited from that approach, I think, because these guys were fighting about everything, and a mediator would have helped them through a lot of the stuff that they felt they had to bring to the arbitration panel.
And Paul, referencing what you were just saying, that kind of goes to what's discussed towards the end of the book, which is mediating assessments protocol, where a certain process is set up to make corporate decisions, and they try to a degree, initially silo things and then bring them all together to make more appropriate decisions, or decisions with less noise.
Yeah, and I will say, as I said, I tried to give a fairly narrow reading assignment for people in the hope that everybody would at least have that little base to bring to today's discussion. But the book is really, I think, very rich in information that would be applicable to a lot of what we do. And even if you don't have the time to get back to the book until a year from now or something, I would just suggest that you kind of hang on to the book, or check it out again from your library, whatever you did, and come back to it. And again, kind of go through it, as there's a lot of useful stuff in the appendix and toward the end of the book. And I know that the math in the middle may turn a lot of people off. I think you can fairly easily skip over a lot of the math if you want, and just kind of get to some of the narrative that's at the end in terms of debiasing, what they call decision hygiene. And I think everybody will find that very useful to think about. I mean, some of it is obviously oriented to a different environment than the ADR environment, but I think everybody will find some valuable takeaways in pretty much any chapter in the book that isn't solely devoted to the Pythagorean triangles and mean squares theorems and stuff like that. I mean, I was a math major, so that stuff was interesting to me, but I get that a lot of people, their eyes will glaze over at some of that stuff. And so I don't mean to suggest that there's nothing in the rest of the book beyond the pages I noted that you will find useful. To the contrary, I think I was just sort of taken aback at every time I read another chapter in the book. I felt I learned something else that I could find very useful to think about as I went forward in my practice of ADR. So we're at the end of the hour. If anybody else has anything they'd like to say, now's a good time to say it.
Just thank you. Yeah, good discussion. Appreciate it.
Thank you, everyone. And maybe we'll find another book and we can do this again, Mark, right?
Very good. Yeah, the book is outstanding. And as far as the math stuff, I had some problems with that, but it supports certain theories in the book. And if you're willing to accept those ideas, I don't know that you have to grind through the math, but I think your comment that you can always go back to the book and pull another chapter or read something that you've read already and get some ideas really holds true. And I would recommend that everybody do that.
All right. Well, thank you, everyone. We'll have, I'm not sure there'll be anything to see on a video, but I guess we've recorded this and we put the recordings up on the website if anybody feels the need to go back and do something. Thanks, everyone. This was sort of an experiment for us. And if you have any thoughts on how it went or how it could be made to go better, we'd love to hear them. And with that, I think we can sign off.
Okay, thank you very much, Rob, and thanks for everybody joining us today.